and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, I'm going to give you your instructions, and then the lawyers will have an opportunity to make their closing arguments. After they make their closing arguments, I'll give you some last final instructions, and then you will finally be allowed to discuss the case amongst yourselves. You should not form any definite or fixed opinion on the merits of the case until you've heard all the evidence, the argument of the lawyers, and the instructions on the law by me. Critical. Until that time, you should not discuss the case among yourselves in any way, shape, or form. I always pause there because I tell people, I hope you're engaged in the trial. I'll be watching you guys like hawks. And listen, I'm staring at you for a reason, making sure everybody's awake, making sure everybody's all right, and I hope you're engaged. It's tempting sometimes. You see a witness who might be particularly powerful, and you get off, you're going back there to get your coffee. Oh, wasn't that witness fantastic? Or, in the reverse, wow, what a jerk. No way, shape, or form. Dancing on that line does nothing but give me a headache and possibly make me start this trial all over again. Your verdict must be based solely on the evidence or the lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. Not here in this case. I'm going to keep you all together at all times, and I'm going to have a deputy escort you. We'll discuss about what you need and where you want to go. I'll accommodate you. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell them, I'm on the jury trying the case, and ask the person to stop. If they persist, leave them at once and immediately report the matter to my court deputy, Deputy Dunkley, who will advise me. Now, cell phones, computers, tablets, or other types of electronic devices. The instruction says they must be turned off while you're in the courtroom. I don't require that. Here's what I require. Make sure they're on silent. Make sure they're on silent. As you've seen a couple of times, and really not that often during our jury selection, there were times we had to have bench conferences when the lawyers came up here and we discussed things. Don't pull your phone out then and start. Do not look at your phone, but I don't want you to have it turned off in case something's coming through that's an emergency or this or that, or your emails. And sometimes in the courthouse, my cell phone has trouble sometimes receiving things. So I don't require you to turn them off. I'm just asking you, please make sure they're on silent, and then no looking at your phones at all until you're back in the jury room. And then at that time, and there'll probably be some repetition here, at that time, because nowadays everybody's cell phone can look at a variety of things, I'm still counting on you. You cannot Google, research, read the newspaper, nothing at all. Please, 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 don't jeopardize all this hard work. So let me just go back to the standard instruction. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After recesses, please double-check that your phones are on silent. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices. When we get there, I'll describe all that to you. If someone needs to contact you in an emergency, I'll take care of that all for you. Trust me. The case must be tried by you, only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on internet website, chat room, or blog. What are the reasons for these rules? We've touched on this during jury selection. These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for what you found. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and you, the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions such as serving time in jail, paying a fine, or both. Now, the attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had I permitted them to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. You all have notepads in your laps. Those are for you to take notes. You don't have to take notes. It's a fairly long trial. It's your choice. But I want you to do me a favor. I want you to write your name on the front of each one of your pads and also your cell phone number. I promise you, we keep those under lock and key. They're for your eyes only. At the end of the trial, I have what I call the super shredder. It's in my office. I shred everything that you have there, and it goes unread. So write whatever you like. When we take breaks, you'll hear me say it over and over, please turn your notepads upside down on your chairs. You see how low that bar is? We have a lot of activity in the courtroom while you're not here, and I don't want anybody to lean over and see what you've written, so you're going to turn your pads upside down. When we come back from a break, I want you to make sure you have your pad. Now, while you're taking notes, Don't become, I've seen jurors so diligent. They got that notepad up here and they fail to see or hear other things that are happening in the courtroom. Also, when you go back to deliberate and you've got your notes, because your notes will stay in here until we go back to deliberate. When you go back to deliberate, don't abandon your recollection of the evidence, just merely what's contained in somebody's notes, even your own notes. Your notes are intended to be an aid to your memory, not a substitute. So they're to help you. With that, as I told you, both sides get to give an opening statement. I'm going to give you a roadmap. I'll read a little bit of this to you later. This is one of those questionnaires I tell the jurors. I got a bunch yesterday. You saw my judicial assistant. During the trial, you may see my assistant come in and drop things off. Sometimes I have lots of things that need to be signed immediately. And this is one of the letters. I kept it aside. Like I said, I got a stack about that high. But one of the interesting comments I got on my last trial, which was a lengthy first-degree murder trial, was, Judge, we want to know more detail about the schedule. Sometimes I don't know. It's on the fly. Some things are happening. But I'm going to try. So today, we believe we're going to go right up to about 12:15. And then we're going to take about an hour and 15-minute break for lunch. There's some things not concerning you that requires. I was very impressed. The jurors want to know, can they start early? And I told them we will discuss that. What's reasonable for all 10 of you and what's reasonable, because, for instance, this morning, I think this kicked off in here around 7:30 a.m. So a lot's been going on, but I hear you and I love it, because the harder we work, we will treat the trial with respect, as far as we can't rush it, but we will work hard. So I love it. Terrific. We'll go to about 12:15 today, depending on where we are with witnesses. Opening statements, I've given each side an hour. I don't know if they'll use it, but the state gets to go first. State, are you ready?
Yes, sir, we are.
You may proceed.